Okay, so we're on the home stretch now. There's a couple of cases that I want to talk about, and it's going to be important that you've thought about these for the first tutorial that we have, or the workshop that we have next week, or maybe this week, depending on when and where in the world you are when we're listening and watching this. So I want to talk about a very famous case, the Yahoo Case, as it's referred to, although sometimes it's referred to as the Nazi Memorabilia Case as well. Cormier, in the chapter that you've been asked to read, talks about it a couple of times, and it's a really fundamental case. Going back to the facts, we're back in the year 2000. But it's fundamental to our understanding of a number of the concepts that these little videos I've been making have been trying to illustrate or get you on top of. So back in the year 2000, Yahoo was essentially the closest thing that we had, really, in some ways, to a search engine. It wasn't really a search engine. It was a platform with kind of links, and you could keep following the links to find the things that you wanted. It had an auction site, and on that auction site, people bought and sold all sorts of things, sort of a very clumsy, in our view now, version of what I guess eBay might be today. Anyway, in France, people were able to purchase, actually all over the world, but our facts take us to France. In France, people were able to purchase Nazi memorabilia. Now, I'm not sure why anybody would want Nazi memorabilia, but it turns out there was a thriving auction site, and in France it was illegal to buy or sell Nazi memorabilia. So an organisation, LICRA, which loosely translated is the International League Against Racism and Anti-Semitism, basically brought an action against Yahoo in France, seeking to get an order to have the Nazi-related material removed from the site globally, requiring Yahoo to pay a fine of about $13 million US, a lot of money in those days, although the fines that large online platforms get these days might be significantly higher indeed. And basically they were asserting that Yahoo had violated the laws of France. They were contributing to the promotion of racism and hate speech by allowing the sale of these items on their platform. So Yahoo responded, effectively saying, we're an American company. Our first obligations are to the laws of America. America has this thing called the US Constitution, like as if none of us had heard of it because we don't watch television or something. Although I suspect the French don't, but who knows. Anyway, so they're saying the First Amendment to the US Constitution protects the sale of those kind of items as part of its wide definition of free speech. And so basically American company, US Constitution wins. It also argued that it wouldn't be subject to French law, and that because it's an American company, and it's actually the responsibility of the purchasers, the people in France, to comply with French law. So if anybody was breaking the law, it wasn't the platform provider, it was anybody who was in France who was either offering these items for sale or purchasing them for sale. Now, it lost that argument in front of the French court, and then rather than appeal in France, it then sought to take the case back to the US. So it basically commenced proceedings in the US court, a district court for the Northern District of California, and it asked that court to find that the French ruling wasn't effective in the USA, which on first instance it did. So LICRA and another French entity that I cannot remember the name of right now, appealed this decision. And ultimately, the Ninth Circuit Court in the US reversed the initial decision, finding that the US District Court didn't have personal jurisdiction over the French parties. So ultimately, this became a choice of law question. But before we get to that, let's actually unpick the arguments that Yahoo had, because I think they're important to understanding how all of these things we've been talking to come together. So there were two key arguments. Firstly, we're an American company. As such, we're US nationals, not French nationals, so we're subject to US laws, not French laws. Yahoo actually claimed that the First Amendment to the US Constitution was basically preempted everything else, and so they could do what they liked. Then they had a second argument, which was, even if that's not the case, it's actually not technically feasible to prevent French users from accessing the Nazi memorabilia on the Yahoo site without imposing a significant burden on Yahoo, which would compromise the user experience worldwide and cost them a lot of money, yada, yada, yada. Ultimately, these arguments weren't accepted by the court. At first instance, Yahoo, basically the court ruled that, Yahoo, you are subject to French law because you've got a presence in France, including a French language website, you've got French employees, you've got offices in France. So yes, you are actually subject to the laws of France. And you can be subject to the laws of France and the laws of the US at the same time. Further, the court found that because the sale of the Nazi memorabilia was illegal in France, it was Yahoo that had responsibility to prevent the access to such items, and it rejected the technical feasibility argument because it looked at what could be done, and basically ultimately required the addition of this geolocation technology that would require Yahoo to pay attention to where its users were and to limit access of those users to only seeing things that were legal in that place. Ultimately, though, the reason that the first instance decision in the US fell over was that the Ninth District Court found that actually that court had no jurisdiction over Lycra and the other French entity. So it explored what that idea was, is in what circumstances will a court have personal jurisdiction over people who do not reside in its territory, who are not located in its territory, and in what circumstances will that personal jurisdiction, that jurisdiction to adjudicate, apply. So the test was one of a minimum contact and fair play and social justice. I'm going to read actually from the decision so that I don't mislead you here. Essentially, it said where firstly the non-resident defendant, so Lycra, has purposefully directed their activities or consummated some transaction with the forum or a resident of the forum, or performed some act by which they purposefully avail themselves of the privileges of conducting activities in the forum, thereby invoking the benefits and protection of those laws. Number two, the claim will arise out of or relate to that forum-related activity. And number three, the exercise of jurisdiction is reasonable. So the express requirement is that the defendant needs to be alleged to have engaged in wrongful conduct targeting at a plaintiff who the defendant knows to be a resident of the former state. So in this particular circumstance, the action that Yahoo brought against Lycra, who originally sued it in France, essentially they're saying, well, actually Lycra didn't have any connection to the US. Conversely, Yahoo did have connection to France, which is why the laws of France and that jurisdiction to adjudicate should apply, but it didn't work the other way around. So the majority in that decision, and there was one dissenting opinion, but the majority concluded that Yahoo didn't make any allegation that could lead them to conclude that there was anything wrongful in Lycra's conduct. As a result, the district court didn't properly exercise personal jurisdiction over Lycra and the other co-defendant. So this is a really important case. It's been referred to a lot both in cited decisions, so in other words, cases in a common law jurisdiction that have been followed, so where there's been a similar dispute and the question has been which laws apply. And it's also been discussed a lot by lawmakers as they've looked at ways in which laws should be made to govern the way parties transact with each other over the internet. So in Europe, for example, Yahoo has been referred to in many discussions about the Digital Services Act and the Digital Markets Act, which have the aims of modernising and harmonising European Union laws on online platforms and increasing the accountability for harmful content online. It's also been referenced in discussions about the responsibility of social media platforms to combat hate speech and disinformation, a really big topic really since 2016 and the Cambridge Analytica, and then subsequently the fake news exposés of the Trump era. In addition, it's been influential in developing international frameworks for regulating the internet itself. So the Yahoo case is one of the key events that led to the creation of the GNI, the Global Network Initiative. That's a multi-stakeholder initiative that promotes freedom of expression and privacy rights online, and it also addresses the responsibility of technology companies to respect human rights. It is one of those industry-led regulating responsibility bodies that was kind of envisaged by Bill Clinton's initiative that we spoke about a couple of videos ago now. So this case, the Yahoo Nazi Memorabilia Case, whatever you like to call it, has had a really lasting impact on the way that we think about online platforms and their responsibility for content that they host, and that need to balance those competing ideas of free speech, fundamental human rights, the ability to do commerce across borders, and the impact that it has when legal people do things that cross borders but don't necessarily stand in each other's territories. I want to talk about another case in the next video, a more recent one involving Twitter, so I'll see you there. Cheers.